Fundamentally, the law of personal property gives people rights in relation to things. The right to use, to sell, to destroy, to transform a thing, a chattel. Underlying this is the idea that the chattel will retain its identity. We will be able to identify the thing that a person has rights to. Sometimes that assumption falls apart, particularly when two chattels are merged so that one becomes an integral part of another. For instance, vegetables on their own are separate chattels, but when they are combined into a stir-fry, they become something else. This is a very old legal problem. The ancient Romans had a doctrine called Accession, which discussed the transformation or incorporation of one chattel into another. But while Roman law can be useful for the interpretation of modern law, it's not an authority, and the nature of chattels has become incredibly complex since Roman times. In this case, a man named Pell had purchased a Chevy truck on hire purchase, then dropped into that truck a better engine, which he had also taken on hire purchase from Rendell. He later missed payments on the truck, so the finance company which sold him the truck repossessed it. But this meant they also repossessed the engine. The question before the court was whether Rendell was entitled to repossess his engine, or whether he lost his rights when the engine merged with the truck. The court found the modern laws of accession to be quite unsatisfactory. They went through many authorities and eventually settled on three questions. Is it realistic to demerge the chattels? What were the intentions of the original owner? And what did justice require? Justice O'Brien said the engine could be detached without difficulty or harm to anything. It had been placed upon the complainant's own Chevrolet 1942 truck and had apparently been removed from it without difficulty. We think the court should take judicial notice of the fact that in these days it is common practice to replace motor engines which are the worse for wear by new or reconditioned engines of the same make and year of manufacture. This is done without damage either to the engine or the motor vehicle. The court should not shut its eyes to what is common knowledge. They found that Rendell was still the owner of the engine and was entitled for it to be returned.